Let's talk about the grant of rights and how it plays with contract law, copyright law, and intellectual property law.
The ACC lawsuits are always in the news, so we're back on the big mountain to break it down for you.
Hey, it's great to have you here again on the mountain. I am JY. This is my good friend Steve. Steve, it is Monday the 22nd. We have our to be continued portion of the hearing down in Leon County, and I know this is coming out as that is going to be going on right now, but I wanted to talk a little bit more about contract law, copyright law, and intellectual property law. We just had Doug Rohan on here, which was awesome. If you missed that and you'd like to see it, check out our channel. And another person that's really active on Twitter, kind of on the other side of the coin, if you will,
Yes.
Is Mr. David McKenzie. I reached out to him to see if he'd also like to join us. Unfortunately, he's having some health issues now, so he couldn't come on, but he did say we could use some of his information from his tweets, and I do want to do that. So that's, you're going to be hear me referencing a lot of what he put out there. He can be found at @McKenzie Law on X, and he is an IP professional or IP law specialist, copyright specialist. And you're going to hear him talk a lot about that. Yes, I understand. I know we have a lot of FSU viewers, I think, and he definitely comes at it more from the ACC side of things, and maybe sometimes throws shade at the FSU arguments. I'm not going to get into that side of it. I really want to focus on what he lays out in terms of the laws and how he reads them and how he thinks they play specific to the grant of rights. And I think that's the most important part here. A lot of this, we've talked about some of this in the past, Steve, but not in too much detail specific to this lawsuit. We've done some past episodes on the grant of rights. We did some deep dives on the grant of rights, all of that kind of stuff. Our longtime viewers certainly know that. But I want to talk, he is specifically talking about the ACC grant of rights here. So...
Yeah, and I'll just say before we get started, before you dig into this, I mean, we had, Doug Rohan on, like you mentioned. Obviously, he's a proud FSU alum and supporter, but he came on to kind of just do his best to give everyone's going to have a certain perspective or viewpoint, but he came on to do his best to give us a kind of just a fair, his fair and balanced impression of how the law works. And I'm sure there were things that certain fans liked, certain fans didn't, whatever.
Right.
And with Mr. McKenzie's same way. He's obviously, if you follow him on X or Twitter, he's obviously a proud, I think, Duke alum.
Yes, Duke alum.
Yes. And he definitely has a certain perspective, looking as an ACC fan.
Right.
But at the same time, he tries to present the law, which is the law is supposed to be fair and unbiased.
Yes.
And obviously there's different perspectives, and in different states they have different specific laws and different precedents. Right. So I think it's a good balance to kind of show the two different perspectives.
Yeah, so I want to get into kind of three separate items. The biggest one we're going to get into is more the contract law in terms of the grant of rights. He talks about intellectual property, which, we can easily tie back to the Leon County case, and I want to get into that. I found this really interesting. He did some of these, a month or two ago, and it's interesting to see how this is now coming up in Leon County. So again, I know we're putting this out while the hearing's going on. I'm anxious to hear the hearing to see how this all counterplays. He also talks antitrust agreements. That has been brought up by FSU. And lastly, he's going to get into a little bit more of the equitable estoppel and waiver, which we've talked a little bit about. He seems to think that's one of the biggest issues at play here. And then he also agrees with Doug Rohan that this isn't going to be going to federal court yet. He says how it could get there, but he's in agreement there. So let's first get into this contract. So David writes that a grant of rights isn't just some typical contract. It is a copyright license agreement. This distinction is very important, he says, as it explains why the length and terms are legally permissible. As we heard in the Florida case, these contracts deal with intellectual properties, and as such, their rights last longer than typical subject matter of standard contracts, service contracts, whatever that case may be. Copyrights typically last for an author's life plus 70 years. So speaking of, written types of copyrights or musical copyrights, whatever that is, an author's life plus 70 years. Trade secrets, which we've heard talked a lot about, protection lasts as long as they remain confidential, valuable, and are not easily subject to reverse engineering. These types of extensive durations reflect the longevity or intellectual property assets, and this is why these licenses are often structured for protracted terms. Therefore, a longer-term grant of rights is not only acceptable, but it also aligns with the established legal principles for IP licensing. He states that Florida State University's voluntary acceptance of the grant of rights and the binding power of copyright and contract law remains to him the key conclusions in this case. Basically, that copyright and contract obligations are in control here and not the changing market conditions or regrets, as he puts it, regrets of one party that's in this contract. To put this into a little bit more detail, the notion that FSU can now retroactively challenge this agreement because the financial rewards are now seen as unfavorable reflects their misunderstanding of how copyright licensing works. Copyright law doesn't provide an avenue for licensors to rescind their rights based solely on a change of market condition or the realization the deal is a bad one. Okay? And I'm going to push back a little bit on this. I'm not push back, but I think there's two things at play right now. And he's specifically talking about one of the two things for me, and I'm going to talk about that here in a minute. The ACC's view here now, so you've heard a little bit of him talking about how FSU's kind of portraying this. The ACC's view is that the grant of rights is about intellectual property, and that property can be licensed and pledged, just like any property we hold or sell. FSU committed this intellectual property to the ACC to be exploited, and there is no mechanism under the Copyright Act for it to be rescinded or withdrawn. I want to be clear, when you hear the word exploited, that sounds like they're going to be taking advantage of someone. That's not what they mean here in this reference. It's not exploited, oh, you're being exploited, being a take advantage of it. It means exploited to be used as they choose, right. Quite frankly. You're giving it to the ACC. Yep. So, again, we're going to get into some antitrust arguments here that he makes next, but I want to provide a couple thoughts of mine. Going over, a lot of this makes sense to me. I get where he's coming from. It's not a lot of what you're hearing from the FSU side. They're presenting a whole different side of this case. So I enjoyed reading some of what he was presenting here, but I want to separate this out a couple different ways. The first thing here is a lot of what he lays out, and you can correct me if I'm wrong. Let me give my first opinion, and then you can chime in. It's clear that the past games follow under these agreements, right? That's the copyright that they have. They've already produced these games. They're already in existence. They have copyright and rights to that past performance, whatever that may be.
Right? We saw that play out with the PAC, where the PAC 2 keeping the rights to the old games.
Right. Yes. And we know FSU is not arguing that.
Right.
They're not saying, well, we want our rights to those old games. They're like, no, we don't care about that. We're talking about future games. So a lot of what was laid out here, and if he was here, I would ask him this. Does this hold the same weight that we just laid out moving forward through 2036, for an example? Or is a lot of this copyright law really based on what's already been made, a book, a score, a musical right, a production of a football game,
something that's already been created,
something that's already tangible, yes. Right? So that would be my question for him. I totally get his point here, but I'm not sure about that future game piece. Any comments you have on that, Steve?
Well, I'll say for that, we see that, IP, intellectual property. One of the companies that we've talked about a lot, Disney. Okay.
Yep.
So
he actually brought up Disney in one of his tweets.
And so Disney has the rights to an intellectual property, whether it's Mickey Mouse or these other ones. And so, yes, they have the rights to movies that have been made in the past or short films or whatever, but they also own that, intellectual property. Somebody can't just come and make a Toy Story movie, that's through Pixar or whatever, because they own that intellectual property, just the idea of that property. Now, we did see, I think, one recent Disney property go into the public domain, but that was
Winnie the Pooh horror show.
Winnie the Pooh, and I think Steamboat Willie
too. Yeah, Steamboat Willie. Right?
Yeah, the original. So But that was a long time,
Correct.
70 years or so. I think he is incredibly knowledgeable when it comes to intellectual property, contract law, granting of rights. My only pushback to him is, I would say, part of that where he suggests that it's just a matter of this. He kind of oversimplifies it, and he sounds a bit condescending, which I think some of the people who follow him on Twitter kind of push back on that, where, well, this is just a simple matter of contract law and intellectual property, and the Florida state attorneys just don't understand the law like I do. Sure. So I would just say, I think that they understand the law. I think they're just making different arguments.
Sure.
His viewpoint aligns with the ACC argument of, this is a simple matter of, this is a contract granting rights to intellectual property, and we're going to follow the terms of the contract, and it's simple. Whereas obviously Florida State's making a whole bunch of other cases that aren't as simple as that.
I wasn't going to bring up Disney, but I'm glad that you did, because he did reference that. And it does make some sense that they can continue to use that intellectual property, that face of
the idea,
the mouse, the idea of moving forward. I guess I don't know how that totally correlates to media rights of a university. But now we get to the second question that I think is even more important, and it's where Judge Cooper's going, and that is, and he talks a lot about intellectual property. And what we've heard, and that's a very strong point from the ACC's side of things, but what we heard from Judge Cooper on day one, and I'm guessing he's talking about it right now as we're dropping this episode, is this IP and this intellectual property not being the property of Florida State University, but this property being the property of the state of Florida. And Florida State, could they have given this outside of the state of Florida? And I mean, we already heard from Judge Cooper, and that sounds like the path he is at least going to begin to go. And I don't know what the answer is to that. But it's interesting as I read some of this, and again, these have been out for a little bit while, and we just heard from Cooper a week and a half ago. I'm anxious to hear how this goes down on the second day, if he goes further with that.
And I think you just nailed, you just hit the nail on the head as far as the difference in the two cases, the two perspectives from the ACC and Florida State, and then also kind of the difference of what we're seeing in the business court in North Carolina and Judge Cooper's court in the state of Florida. Is this a matter of just, two private companies or nonprofit entities having a contract, and it's a very simple contract, or is this a matter of the rights of a state, of public property, which obviously gets into a much more complicated area. So, and I'm sure the ACC would like to just keep this as simple as, hey, this is a simple contract. These are the rights. This is the intellectual property. You granted us the rights. End of story.
You got it. Very interesting, I think, as we move forward with this. So let's get into the antitrust agreements. Mackenzie discusses in what he says is FSU's over-reliance on antitrust agreements. He points out that antitrust laws are designed, and we've said this a little bit before, and he repeats it here, but are designed to protect competition from harmful monopolies and unfair business practices, basically practicing the public from those sorts of things. They are not a shield for subsequent realizations of bad deals. And he does like to jab FSU on this. You can't come back on a bad deal. You can't come back and I'm trying to be fair. I tried to leave out some of the more aggressive types of wording here, but again, this isn't a shield for a bad deal. He goes on to state that antitrust laws cannot override the well-established principles of federal copyright laws. Mackenzie concludes that using the antitrust argument is a diversionary, that's right, tactic and irrelevant to copyright laws. His extensive experience in IP law leads him to believe that the grant of rights is a copyright license and not a restraint of trade. So I thought that was important to bring up because he is, again, as I said in the beginning, an IP law expert.
Yeah, and honestly, that line of thinking there as far as the copyright law versus the antitrust, I think it makes a lot of sense, that line of reasoning, and I think we kind of heard something similar from Doug Rowan.
Yes, we did.
And so to me, that really makes perfect sense. Again, I would just, like you mentioned, he talks about he's really trying to boil this down to a case of basically implying that Florida State, they've now decided they don't like the deal, they want to get out. Obviously, the allegations that they're making in their lawsuit are much bigger than that. But his perspective is this boils down to a copyright law, a contract of a copyright law, so copyright law should apply, and it's a pretty simple matter.
Well, and Mackenzie gets into a lot of the unfair dealings, fraud. I left that out of this episode because that just gets people fired up. I tried to pull out the pieces that, to me, and that's why I really appreciate our discussion with Doug Rowan.
Yes.
And we drove that, and I appreciate him letting us drive that. Here's what we want to hear about, and here's what we want to hear you dive into a little bit more detail. And I felt we got a couple really great nuggets out of that. And that's what I tried to do here. I'm trying to stay away from this salaciousness. So let's get to the last one here. He talks equitable, estoppel, and waiver. He states this may be the best argument of the ACC. This principle prevents a party from repudiating an agreement if they previously accepted and enjoyed its benefits. In this case, the ACC states that FSU has received millions in additional revenues under the grant of rights, including the increased TV exposure through the ACC network. The ACC states that since FSU has seen substantial financial gains, they are estopped from challenging the validity of the grant of rights. While FSU may not like the amount of money they have received over the past 10 years, this is not a ground to invalidate a contract. And we've talked a little bit about this in the past, but everybody likes to talk about the salaciousness and what everything that's going on in the hearings, and this is what he said, and this is where they maybe got caught up. This is a big deal, and I think he lays this out really well. I'm not saying it's the end game, but I definitely think it's a really good point that we're not hearing a lot about right now. I mean, we talked about it a little bit with some of the ACC briefs that they put forth, but it's a big deal.
And that was brought up in Judge Cooper's court. I think it was actually the FSU attorney that brought that up as an argument the ACC would make of, hey, we've been enjoying the fruits of this contract. We've been performing under this contract and getting money, each year, however many years. Obviously we've been enjoying the fruits of this contract. So it's a very logical point, I think, from him. And if you look at it again as a simple matter of this is a contract, and you look at it as a copyright law, and just because you don't like the deal now doesn't mean you could just tear it up. I think it makes a lot of sense. Now, obviously, and we don't want to get into all the different parts of the case, it's a lot more complicated than that. It's not just a simple contract of copyright law, but that's for another show.
Absolutely. Well said. Well, I know the hearing's going on right now. Steve and I are either listening to it or following it on someone on Twitter, or we're going to be getting back up to speed on that, and we'll try to get an episode out on what hopefully is finalized in the hearing here on Monday. We'll get that out towards the end of the week. I'm not expecting any surprises, but we like to summarize things, so we will certainly try to do that. Hey, make sure you give this one a like, subscribe if you like our content. We'll see you guys next time on The Big Mountain.